and welcome to Chug Live. Today we are doing an emergency session live on the new $100,000 H-1B proclamation that was recently announced. We are joined today by partner and attorney Mishita Jethi from our Edison, New Jersey office and attorney Jagan Tamirisa from our Herndon, Virginia office. Thank you so much for taking the time to be here with us today. We will be answering all of your pressing questions on this topic. So let's get right into it. Let's start with Jagan. Do you want to tell us what exactly does the new $100,000 H-1B proclamation say?
Yeah, good morning, Arianna, and good morning, everyone who's logged in here. Thank you so much for joining today. We'll try to be as brief as possible on this. So what exactly happened is on September 19th, the president issued a proclamation restricting the entry of H-1B workers unless their petitions are accompanied or supplemented by $100,000 in payment. And then the proclamation continued to say that USCIS will not approve the petitions filed after September 21st unless it is accompanied by the said payment. And Department of State was tasked to verify the receipt of the payment before issuing visas, and the Custom and Border Protection will enforce this at the admission. Now, the phrase used in the proclamation is accompanied or supplemented by 100,000 payment. Now, what this practically means is this means 100,000 payment should be submitted at the time the H-1B petition is filed with the USCIS. In other words, the package should include proof of payment. The other term used in the proclamation is supplemented by, and the reason probably why it's there is to cover situations where a petition may have been filed without the said fee, probably due to clerical error or missing attachment, et cetera, but the employer later adds the payment to complete the filing. So this phrasing prevents employers from arguing that late payment is invalid. So, and USCIS has been given the discretion to accept the fee after the petition submission rather than rejecting outright as long as the payment arrives before adjudication. So the best practice is to include the payment at the time of the filing.
Can you tell us when exactly this takes place and how long will it last?
So the effective date is September 21st, so which means it's already in effect, and it's going to be valid for 12 months, which is through September 21st of 2026, unless it's extended further by the president. And it's only applicable prospectively, which means there will be no revocation of existing visas or petitions that have been filed before September 21st.
Can you tell us a little bit about who is covered and who is excluded under this rule so we can get a better understanding?
Sure. The important thing to consider here is the effective date, which is September 21st. So any petition filed on or after September 21st, whether it be cap subject or cap exempt, is included under this rule. Petitions that have been excluded are those that have been filed before September 21st, petitions that have already been approved by the USCIS before the effective date of this proclamation, people who have already received valid H-1B visa stamped in their passport and have not yet traveled, and of course any renewals, extensions, amendments that are filed in country. However, there is still more guidance needed from the government. Any petitions that is filed for consular processing may probably require this fee, but more guidance is expected to be released by the Department of State.
And are there any exceptions or national interest waivers that we should know about?
Yes. So as soon as this proclamation came out, we all huddled together. We have over 200 professionals, legal professionals in the firm. So we all, went through this question by question. And we feel that, the proclamation did grant or did say, at least at this point, that there are going to be exceptions case by case or industry-wide. So so that if the hiring such an H-1B worker is in the national interest and does not threaten US welfare or security, then they will be exempted. However, no department, be it USCIS, Department of State, or CBP, has given any written memorandum or any sort or guidance as such on how these exemptions are going to be applied. But one can look back to the COVID-19 travel restrictions that were put in place in 2020-21 by a similar presidential proclamation. And that proclamation created national interest exceptions, and certain workers were excluded at that point, where such as professionals, such as healthcare professionals, researchers, workers critical to US economic recovery, those involved in critical infrastructure like in IT, communications, energy, defense, transportation, etc. So these professionals were provided waivers. So I think the recent notification did come out that healthcare workers would be exempted from paying the $100,000 fee. So both the COVID NIE as well as the 2025 proclamation are relying on the same regulatory authority, which is Immigration and Nationality Act to Section 212F, that authorizes the president to restrict entry and both carve out national interest waivers. So it is expected that a similar sort of national interest waiver may probably apply here. And I think in the days to come, we might see how some guidance from the US government on this.
Wow, really crucial information there. Thank you for covering that, Jagan. Mishita, I want to ask you a little bit about what this looks like from an employer's point of view. Can you tell us a little bit about who is required to pay the $100,000 fee, the employer, the worker, or both? What do we need to know here?
Of course. Thank you, Arianna. Good morning to everyone who's joined in. Good afternoon to those on the East Coast and beyond. At this time, although there is no clear guidance, but since it's, since the proclamation covers H-1B, it is expected that the employers will be bearing this cost of $100,000. As Jagan previously already explained, that the proclamation says that the petitions should be accompanied or supplemented by this fees, which means at the time of the filing, the employer would likely pay this $100,000 fees. Jagan also, alluded to the fact that we don't have very clear guidance as far as the consular notifications or when the actual application of the visa is concerned. So it is possible that in some cases, the employees may have to carry proof of that 100,000 filed when they apply for the visa. But I think in terms of the payment, it seems more likely than not that it will be the employer that will have to bear the burden of the fees. So, and also it will not be double. So it won't be that both the petitioner as well as the beneficiary, both the employer and the employee will be required to pay. As has been clarified, I think both by the press secretary and otherwise, this will be a one-time fee. So it will only have to be paid by one entity once.
And what about this fee? Does it apply to new petitions only? What about transfers, amendments, extensions? What do we need to know regarding that?
Right. So although the USCIS memoranda does not use the terms, transfer extensions, but they do use the word renewals. So when we read that, it certainly appears that this fee will apply to what we call as, new cap subject petitions. That is what the best inference we have all been able to gather at the moment. So for anyone who is applying for a renewal of their H-1B, whether it is through an amendment or a change of employer or extending their current H-1B petition, it appears likely that this particular $100,000 fee will not apply to similar petitions.
And what about how this impacts capped exempt employers like universities or nonprofits? What does that look like?
Right. So as of right now, we do not have any clarification on this. There does not seem to be a carve out for cap exempt employers or universities. But I will say that based on what Jagan has also alluded, since there is a blanket exemption provided or an exception being given for national interest exceptions, if these nonprofit entities or if these cap exempt sponsors are able to demonstrate that the position for which they are filing this H-1B or the worker is coming in to fill in a position that is in the national interest, right? Or if it is something that will benefit the US economy, then they may certainly seek a waiver of the 100,000 petition. So while there is not a blanket exemption being carved out, I think that a lot of universities or cap exempt sponsors might be able to show that they are eligible for this NIE. And then again, as we know that the NIE can be granted to an individual petition, it could be granted to one particular company, it could also be granted to an entire industry in the discretion provided. So it is also possible that a lot of universities or a lot of cap exempt sponsors could potentially band together and ask for, a blanket NIE.
Wow, really good to know and great perspective there on that. If you are watching this and in this situation and have questions, feel free to reach out to us. We're happy to guide you through this. So can you tell us exactly at what stage is the fee due? Is it filing with USCIS, consular processing, both?
Right. That's a great question. So as of right now, both the presidential proclamation as well as the memoranda that have been issued by USCIS and CBP make it appear that the fee will have to be submitted at the time of the H-1B filing, right? So when that petition is filed, USCIS, before they adjudicate the petition, will have to verify whether or not the fee has been paid. As Jagan has already clarified earlier, it could be that in case a particular petitioner either inadvertently misses out on submitting that $100,000 fee or is not able to submit it at the time of filing, there may be some mechanism by which USCIS could either raise an RFE or, not outrightly reject, but maybe ask for that particular filing to be sent. So it seems more likely that it will be at the stage of H-1B filing. But even when that is done, I think if the H-1B visas, when they have to be applied for based on these petitions, it is likely that the beneficiaries may be asked to carry the proof of the payment.
Can you tell us about the documentation that might be required from employers to request an exception? What does that look like?
Right. So again, we don't have guidance in this particular proclamation, but I will rely on, on the COVID-19 NIA exceptions that a lot of us had drafted. Typically, they would be an attorney letter or a letter on behalf of the employer/petitioner, where they give details of what is the position that this particular beneficiary or foreign national is being required to fill in, and how those job duties will help the US economy or assist, in the recovery of the US economy as it was at that time, or how it might assist with, combating COVID-19 as it was at that time. So given that the presidential proclamation of 2025 also uses language which is similar about making sure that US workers are not harmed, right, with these particular positions being filled, we assume that if petitioners, sponsors, employers, or attorneys have to provide documentation, they will have to give details as to how this job does not take away the work from maybe US workers. So maybe any document or data to support that there aren't enough US workers for this particular position, or that the employer has perhaps tried to fill the position, looked out for workers, or perhaps even give details about the beneficiary foreign national themselves, showing how highly qualified they are in that particular field. Perhaps they are so unique and they are so, they're just like, they have such advanced knowledge in that particular field, which is not very common amongst other people. So, which might be similar to how people prepare O1 petitions, maybe not that much in detail, but tending towards that. So, I think all of that documentation, all of that information will have to be presented to seek the NIE waiver.
Wow, great insights on that. I want to ask you one more question from an employer's
course.
point of view. How should companies adjust hiring and workforce planning in light of this change?
Right. I think that's a great question. And I'm sure that, employers, particularly those that rely on a lot of highly skilled foreign nationals, must already be thinking about it. I think one way, probably for most of them, is to see if they can look to hire people on other visa categories, right? Whether they can backfill these positions either with students who are on F1 or use intra-company transfers, which is the L visa, perhaps see if they can find exceptional or extraordinary ability foreign nationals to do some of this work, which could be the O1 visa, and various other categories which currently have not been brought under the blanket of this proclamation, right? As you know, this proclamation only impacts the H-1B category. And also, so far as we understand, this is prospective in nature. So perhaps employers might look to hire foreign nationals who already have received their H-1Bs in the previous years, right? So they can continue to extend their H-1B status rather than seek new H-1B status holders. In the long term, my guess is that, if the industry is not able to fulfill the requirement of their work through US workers alone, they might either, seek to carve out exceptions for the entire industries by showing this gap. They might look to either, send some of these jobs offshore. Or I don't know, it might be that the industry and other subject matter experts come together to carve out an entire new visa category, which may not exist at this time, to fulfill this gap that may come up if they're not able to hire enough people on H-1B visas.
Wow, such great insights. And a great point that you brought there too at the end. There are so many other visa options as well that, people can explore. So if you are watching this, whether you're on the employer side or worker side, and you have any questions, please comment them below. We will get to them at the end. Let's look at things from a worker perspective. Thank you so much for the other perspective, Mishita. Jagan, if you can cover this worker perspective, if I'm already in the US on an H-1B, am I subject to the $100,000 fee?
No, if you are already in the US on a valid H-1B, you're not impacted. Any petitions filed and approved before September 21 are not subject to this fee. So in-country exemptions apply to all extensions, amendments, transfers, etc.
And what happens if I travel abroad and I need visa stamping? Does that trigger the fee?
Well, if the petition was filed after September 21st and you're traveling abroad and need a visa stamping, then yes, that particular petition will come under this proclamation. But if your petition was filed before September 21st, then it looks like you can obtain your visa stamping and travel normally based on the press release released by the White House.
Can you tell us how this affects F1 students on OPT who are transitioning to H-1B?
So this year, the H-1 cap selections that happened in end of March, and all the filings were completed by June 30th. After which the USCIS came out and said there are not going to be any more further selections. And gave a memorandum saying that the cap has been met. So those F1 students who have filed their petitions to transition to H1, because it happened before September 21st, you will not be subject to this fee, and you should not have any problem at the consulate. Going forward, any petition that is going to be filed after September 21st for F1 students, they will be subject to the 100,000 fee. However, if they are filing for a change of status, meaning those students are within the United States and are filing a change of status, they don't have to pay this fee. But if they go for a consulate, then potentially they will be required to pay this fee.
Okay, really good to know. What about the H-4 dependents? Are they impacted in any way through this?
No, this proclamation only applies to principal H-1B petitions. So H-4 applications are not going to be affected directly. But obviously, it goes without saying that the H-4 is tied to the H-1B. So obviously, if the H-1B petitioner, the beneficiary is impacted, then yes, collaterally it will impact the H-4. But as such, this fee is not applicable to H-4 dependents. It's just a one-time payment.
And if my H-1B petition is already approved, but let's say I haven't entered into the US yet, do I need to pay this fee?
No, if your petition was filed prior to September 21st, the effective date. So if it has already been approved before or filed before September 21st, you are grandfathered and you're not subject to the fee.
Wonderful. Thank you for covering those questions. If you have any other questions as a worker, please comment them below so that we can get to them. Mishita, I want to talk a little bit from a practical and strategic point of view, what this looks like and what you think from your point of view. What immediate steps should employers and workers take right now?
Right. So I think the first thing that I would say is, honestly, it has been a very chaotic and rough past weekend. But as we're seeing, more information come in, I would strongly suggest that the first instinct, which happens to be, of panic, we should try and, minimize it as much as it is possible. On Friday, when it appeared that this proclamation will apply to everyone, of course, we read so many news articles that people scrambled to come back to US, those who were stranded outside. So I think now that we have a little bit more guidance and we know who may or may not be impacted, at least, on a very broad level, I would really say that, the best course of action would be to not panic. And as we already know, those who already have H-1B visas stamped, their travel is not impacted. So if you are able to travel or if you have travel plans, you can continue to go with it. However, please do keep in touch if you're a foreign national employee with your HR, with your managers. Ensure that if you have travel plans, they are only those which are urgent. And if you still have to or need to step out of the country, you should just be mentally prepared that there may be delays, even if you are admitted back, right? Just as CBP and USCIS and the State Department slowly coordinate this particular proclamation and the memoranda and the various, practice pointers, I'm sure that there will be a slightly lean learning curve, and initially there may be a little bit of training issues. So if there are certain delays, please anticipate them, right? So which is why if you're able to stay put, please do. But if you have emergency travel plans, please be mentally prepared that you could face potential delays. Beyond that, obviously, since the deadline has already passed for filing the petition, if your petition is already filed and it remains pending, you are at the moment exempt from the fee. So do not, get too worried about it. Do not, I think in terms of reaching out to the HR, you should already know that you will be grandfathered, as Jagan already said, so you should not worry about those. So I think both from the HR perspective, employer's perspective, please allow them to utilize all of their resources and time, right, to strategize for the particular cases which are getting impacted, right, rather than all the other cases which we already know by now that are not impacted, so that they are able to make plans specifically for people who might be in the crosshairs right now. So I think the beneficiaries, the foreign nationals, it would be good if you keep up with your news, whether, from all of these webinars that we will be hosting through the week, so that you don't have to worry your employers right? So keep up with the news. From the employer's perspective, we are here, all of us. If you have any questions, please reach out to us. We'll be continuously updating our news alerts as and when more information comes in. So that's what I would say. In terms of strategy, please make sure that you are in close contact with your immigration providers and you're keeping up with these changes as they're coming in, so that if you have to tweak any strategies, they can be done in real time.
Absolutely. And as you said, don't panic. We're here to help and answer your questions. Can you tell us a little bit about the risks involved if somebody decides to ignore or maybe just misinterpret this rule?
Right. So I think in terms of risks, as I said, because there will be a steep learning curve right now, both for the CBP officers and probably the consular officers who have to now issue these new visas, you might anticipate some delays. I have spoken to clients, continuously since yesterday and over the weekend as well. While so far, and also I think, a lot of practitioners have been very kind and generous to share a lot of information about, cases that have been approved yesterday or visas that have been granted yesterday. So far, it appears that the consulates have, been able to issue visas for petitions that were filed previously, which were approved. So there have been very few instances where the consular officers have said, okay, we're going to hold this passport until we get further guidance. So that is something that I would expect and anticipate, that there could be some visa delay. In the meantime, both the employer and the employees, what they could do is marshal all of the documents and, the press release, whether it's the CBP memoranda or the USCIS memorandum, and keep copies of those. So if you're going to attend any of your visa interviews within the next couple of days, right, it'll be great if you are armed with all of this information, so that if, let's say, the consular officer is not very well versed yet, or they're still training, you could potentially let them know why you would not be impacted by the proclamation, right? So I think the easiest way to say this is help them help you, right? If you know the law, if you're aware of it, if you're updated with all of the current memorandums and practice pointers, you could potentially help them out, right? So do not panic. Make sure that you are abreast of all of this information, and just anticipate some delays if as everyone gets accustomed to this new normal, right?
Understood. I know earlier we mentioned a little bit about the alternative visa options. So let's say the H-1B does become cost prohibited. Can you tell us a little bit about the alternative visa options that should be considered?
Sure. So I think, as we discussed earlier, in addition to the F1 visas, which is granted to students and which authorizes them to work in the US for a period of 1 year if they have non-STEM degrees, and 3 years if they have STEM degrees, there are also other short-term visa options, right? There are the TN visas, which are for Canadian nationals and Mexican nationals. There is the E3 visa, which is for the Australian nationals. Both of these visa categories are also for specialized work, right? So highly skilled workers, but they're exclusive to these particular countries. So if you do have an alternate citizenship, right? If, let's say, you are a Spanish national as well as a Mexican national, or if you are, a South African and Canadian national, or if you have dual citizenship between Australia and Finland, try and leverage any alternate citizenship that you might have, which allows you to get a worker visa. And this is something that, beneficiaries should be able to tell their employers, right? Maybe help them see if there are any alternate visa categories that are available to them. Outside of that, obviously, if foreign workers have worked with affiliates of their US employers abroad for a period of 1 year in either a specialized knowledge position or in a managerial position, the US employer could potentially bring them back on what is known as the L1 visa, which is the intra-company transfer visa, right? So that could be something that both employers and employees could explore. For those who, as I said, who are extraordinary, who have extraordinary ability in their field of endeavor, who are probably in the top 1% of, the work that they do, or any work that they're doing which is of national interest, of national importance, they could consider either the O1 visa or even consider getting an NIE for their H-1B petition, right? Other than that, if you have any other means of getting work authorization, perhaps you have your H-1B visa, perhaps you have your spouse on H-1B who perhaps is exempt, or maybe their employer has agreed to pay the 100,000, but perhaps your employer may not be able to do so. Consider switching to H4, and if you are eligible for H4 EAD, try and file that. So, you have work authorization. Obviously, it ties you up, as Jagan said, to the H-1B, but if H-1B for every employer becomes cost prohibitive, then, some sort of trade-offs may be given. Other than this, there are also visas for performers and artists. So if that's the field of work in which you are, consider getting the P visas file. If you're a religious worker doing that sort of work, you could consider getting the R visa file. So there are certainly a lot of other various visa categories that could be explored. And I think, more or less, if the H-1B visa category becomes so cost prohibitive, I'm sure that employers automatically will start exploring these other options. So as an employee, you can maybe assist your employer, see if you fall within any other category. Just try and explore those.
Great points. Can you tell us a little bit about the legal challenges that might be expected and how that might affect enforcement?
Yes, absolutely. So legal challenges are expected, both for the proclamation as well as the memoranda issued. As some of you might remember, earlier in January, when the administration had come out with another similar proclamation on ending birthright citizenship, there were immediate legal challenges that were mounted, across various courts. And a lot of petitioners plaintiffs were able to get what are known as TROs, temporary restraining orders. So I'm certain that similar legal challenges could be mounted against this proclamation as well, and plaintiffs could get TROs, against the proclamation. We don't yet know of any legal challenge yet filed, any lawsuit yet filed. It could be imminent, and depending on which court it is filed, what kind of injunction is sought for, we are sure that within the next few days, if not the next week, we should hear back on some sort of an injunction. It might limit the operation of the entire proclamation. It could perhaps limit the operation of the proclamation to certain categories, or it might defer that the proclamation will come into effect at a future date unless the rest of the policy, etc., is decided and discussed. So yeah, I think that we should certainly expect and anticipate legal challenges and lawsuits to be filed imminently.
Good to know. I know we do a lot of immigration updates on our website. If you sign up for that, you'll get an email. But aside from that, what is the best way to stay updated as new guidance is released?
I think you've already covered it, whether it is our website, through our webinars, through our alerts. We are constantly keeping not just our clients up to date. We also ensure that anyone who signs up for, our newsletter is also given all of this information in real time as soon as we receive it, and we make sure that these alerts go out. So keep reading all of those. Keep connected with your immigration providers. Whether you are keeping up with the news. I mean, I think these days everyone has to also have an X account and perhaps a TikTok account, because who knows, where we are hearing these proclamations at. But I think the one thing I will say is that if you are in the US as a visa holder, you really, particularly in the times that we're living right now, you really have to sort of keep up to date with the news, because sometimes even a matter of these few hours could really make a difference. As we were discussing on Friday, so many people who were perhaps in another part of the world, those who were up and who were probably reading the news or, who were keeping up with it, were able to take some decisions perhaps faster than others. So I understand that it may be very onerous, but I think, that's just, those are the times in which we're living. So please stay up to date, sign up for these newsletters, for alerts. Make sure you're listening to webinars wherever legal experts are providing information and answering FAQs so that you can be better prepared and make decisions accordingly.
Absolutely. If you are not already signed up, you can go to chug.com and sign up for our newsletters. We can get to a few comments if that's okay with you guys. We have one from Melinda asking, for those petitions that have been filed before the effective date but have not been approved, will this fee apply?
No, it won't. As I think Jagan has already mentioned, that any petition that has been filed prior to September 21, 2025, they are already grandfathered in. So even if it has not been approved, so long as it has been filed before September 21, 2025, those petitions should be exempt.
Wonderful. Thank you for clarifying that. And then we do have another question from Tushar. For the folks who are heading to their home country and are required to stamp their H-1B visas, whether it's the first time or extension, does this apply to them?
Jagan, do you want to take this?
Yeah. No, it doesn't apply as long as their petitions were filed before the effective date, September 21st. So they should be exempt.
Wonderful. Thank you for clarifying that. If you are watching this and have any additional questions, feel free to send us an email anytime at info@chug.com. We would love to help you out. We'll be back tomorrow with more updates. Thank you so much, Mishita. Thank you so much, Jagan, for taking the time to answer all of these questions for us.
Thank you so much.
Thank you, Arianna. Have a good day, everyone.
Thank you, everyone, for tuning in. We'll see you tomorrow.
Thank you.